That wasn't very hearty. Is it because the room's tired or because we're all done with today? I kid. Okay, just a little, my name is Cher, by the way. This is Frank. And the on and off the charts, I just want to explain a little bit because we're going to have some kind of overlap. But the first half of the presentation will be what types of income can be included on the chart if you're calculating child support. And we'll have some little anecdotes in there about particular things that relate to the children, etc., that need to be taken into consideration. And then we'll also, in the second half, talk about some expenses that could be included in the chart or not included in the chart. So for those of you who are not family law attorneys, this is probably going to be maybe enlightening, I hope. But for the rest of you who are in family law, hopefully we're giving you a good perspective of what's going on with the current laws that have to do with the child support. So I'm going to get us started talking a little bit about just what exactly is included on the chart. Let's see where we are here. Okay, so obviously a lot of this stuff we all already know what can be included in gross income. Salaries, wages, commissions, dividends, basically anything that can give the person any type of money. In addition to that, if they're receiving any type of money from their trust, if they have trust income that they're getting regularly, if they have annuities that they're receiving on a consistent basis, any type of partnership distributions, whether they are receiving them, actually receiving them, or they have control of whether or not they receive them, needs to be taken into consideration. Social Security benefits. And one of the issues with the Social Security benefits that we all need to kind of take into consideration is whose Social Security is it? If the parent paying support is receiving Social Security, it goes into their income. But we also, on the flip side, have to remember that if the child is receiving any type of Social Security from that parent's disability, then there's a dollar for dollar credit if they're the parent who's paying support. Okay, so that's just one of the little things to kind of think about also when you're looking at Social Security. And then, of course, if there's any type of retirement benefits that the parent may be receiving on a consistent basis as well, then that would be something that is actually included in their gross income as well.
An interesting thing about the annuities, there is a case out there that discusses a payor parent, payor non-custodial parent of child support who receives personal injury settlement by way of an annuity, that the courts have found that in a circumstance such as that, because the personal injury settlement is paid in the form of an annuity, that the annuity can be considered in that circumstance as income for purposes of child support. Even though the personal injury settlement in and of itself may not be taxable on your income tax return, the courts do have some discretion, and the court did uphold in a case, I think it's a let's see here. It's the Toronto versus Child Support Enforcement is the case. I have the site. But they did uphold the child support enforcement's consideration of the annuity. In this case, that again, the payor parent was receiving the personal injury settlement by way of an annuity, and that got dumped into the gross income line 1 of the Form 14 charge.
Also, if you guys have any questions as we're going along, please feel free to just raise your hand and we'll go ahead, ma'am.
So I have a question on back to the Social Security benefits. You said it is included in the payors. Does it also be included in the person receiving child support receiving Social Security benefits on behalf of the child?
The child's benefits are not included as gross income. The way that they are calculated is you look at it in two different aspects with the chart. Whether or not the parent should be getting a credit, so the payor would be getting a dollar for dollar credit, and if there's enough to cover all of the child support, then the disability is all they would receive. But the child's income does not get included on mom's. We'll just say mom is the one receiving support. The child's income is not included on that, but it is considered in whether or not the child has enough income to cover their own expenses. So there's two different schools of thought on that, whether or not there's a credit for the payor, and also whether or not the child has enough of their own income to cover their expenses. Any other questions at this point? Okay, moving on to the next, just a couple more items that can be included in gross income. Most of this, obviously everybody kind of knows already, but if there's any kind of workers' compensation, severance pay, anything like that that the parent has received, that all would be included as part of the income. Now,
and just briefly, the workers' compensation, because you're being compensated for lost wages, that tends to be the crux of what the courts are relying on and dumping that into the gross income figure for the payor spouse.
Correct. Now, also with the final thing here, military allowances. If you have a parent or two parents who are in the military, not only is their base pay or their reserve pay included, but if they are on active duty or if they are receiving any type of additional income, whether that be for a housing allowance, food allowance, anything like that, that actually also gets included. So it's not just looking at the issue of whether or not they have a base salary. You have to kind of look at what else are they getting also in the form of active duty pay is one of the big things that actually increases their income quite a bit. That's all something that needs to be taken into consideration as well. And in addition to that, if we do have somebody on active duty, it's a good idea to kind of think about when they might be off of active duty as well, because if they're going to be off active duty in 6 months, and you have them at a $9,000 a month income, which is going to be cut in half basically when they lose their active duty pay, then that's something to consider so that people don't have to automatically come back on some type of a modification. Okay, now on W-2s. The common practice for most of us is we get a W-2 from somebody and we say, oh, the chart's going to be easy because they're W-2 employees. So we look at whatever's in box 1 and we average it for 3 years or whatever and say, okay, this is what the parent's income is. What a lot of us overlook when we're calculating gross income is what's in box 12. And I don't know how many of you actually looked at your own W-2s if you have them, but when you're looking at box 12, that's all of the items that are pre-tax. So if you have, for example, employee benefits that may be paid that your person is not getting taxed on, or if you have some type of an employer contribution to a 401k, if you have any type of an HSA, things like that, based on certain scenarios, that may also be included back into their gross income. So that explains part of the reason why when you look at a W-2, the income for purposes of box 1, which is your wages, and box 2 and 3, which is the Social Security and Medicare, are usually different. And that is the reason why. Because if you take somebody's final pay stub for the year, that's actually going to match what's in Social Security and Medicare. But box 1 has now taken out everything that was paid pre-tax. So if you are the person who is trying to get child support, or you're the person who's also trying to reduce child support, those are things to kind of take into consideration if you're trying to increase or decrease their income for a W-2 purpose, okay? Also, very helpful resource, I know that Brad and a couple other people have mentioned this, the IRS website actually has very specific guidelines that you can print off, something that explains the entire W-2 process, what the government would include back as income, etc. So I encourage you, if you have any questions, use the IRS because they have all these publications already out there.
And specifically, the IRS definition for income is not a definition the court has to follow. The court may consider the IRS's definition of income, and the court may consider a tax return for purposes of calculating gross income for the payor and payee spouse, but they don't have to follow that. So, and that's important to keep in mind that you may have a tax return that you're trying to use. It's good evidence, but it's not determinative of gross income.
The other thing to also look at if you're considering any type of W-2 employee is whether or not during the pendency of the case they have increased their contributions to their 401k, which are usually pre-tax and also will eventually reduce their income, or if they have any other expenses like their HSA or anything that they're now contributing more to or less to. Obviously, in addition to just the child support amount, that will also come into play if you're trying to divide any pension and they now, or a retirement, and you've now decided they're either reducing or increasing whatever amount they put in there. One of the other options for a added in income that could be increased for child support purposes, you'll kind of notice a trend on most of these are going to be very similar, but in order to include trust income, now this is income that is received by the parent, there has to be certain qualifications that have to be met, and the biggest one is really, does the parent have any control over the distributions, and are they able to consistently keep getting the distributions? So for example, if they are not a co-trustee or completely in charge of the trust, and it's not guaranteed they'll get the same amount of money every year, or they've only received it one time, the court can kind of weigh all of that to determine whether or not to actually add it into their gross income. Self-employment considerations. Now, I know that a lot of people have dealt with the S corporation, with people who have their own business. What do we add back in? What don't we add back in? How do we come up with the income for these people? Number one thing to remember is you have to determine whether there is a difference between not a difference, but whether or not it is an S corp or it is a C corp. Because if it is an S corp, there are a lot more expenses that could be personal in nature that could actually be added back into the income as opposed to whether or not it is for a business. So I'm going to focus a little bit on just the S corp and tell you what expenses can kind of be included back in. The general rule when you're dealing with how to determine the income for a person who is self-employed with an S corp is that you take the income that's on the tax return. So after they run their Schedule K and it has all of their business information on there, then whatever their profit or loss is what their income is. Now, obviously we've all seen, sometimes it's a negative number for years in a row. So they could be negative 10,000, negative 8,000. How do we calculate the child support? At that point, we have to start looking at what expenses can be included back in. And in order to do that, we have to kind of take a look at what are the expenses. So automatically, what gets added back in? If they're using the house as a business expense, you're using a home office, etc., any depreciation or expenses that are related to the house, automatically added back in. If there are travel expenses that are not related to the business, we just paid for the entire family to go to Florida on the company Amex, but it had nothing to do with my painting business, that's going to get added back in. Here's the difficulty. Do you need an expert to look it over? How do you know what the expenses were or weren't? So really what you have to look at is, are the expenses something that is ordinary and necessary for the business? So for example, if we use the painting business example, if you're looking at a expense that's for something that's unrelated to possibly paint or materials, then that would get added back in, especially if you can tell it's a personal expense on behalf of the family. And you will see often with these clients, they have a business account that they freely write checks to their mortgage company or to their utilities, paying all of these bills, and that's where you're going to have to get really creative in trying to justify how they spent all of this, or the other side is going to jump right on it and say it all needs to be added back in as part of their income. Okay?
And in circumstances such as that, it's always better to retain an expert to help flesh out the personal versus the business expenses. Some of them are right on the line. And you may look at it, and the person, a trained individual might look at it as a personal expense, but it may in fact be more appropriately categorized as a business expense. So when you're getting to the S corp, particularly those who have an S corp that do such as Cher had suggested, like the mortgage and expenses out of the account, you really need someone to delve in and start fleshing out the differences between the individual expenses and the S corp expenses to present that evidence in a coherent fashion.
One of the expenses that is not included back in is the cost of goods. And there's a long line of cases out there on what should be considered a cost of good and what isn't. And again, everything has to go back to what is ordinary and necessary for that particular business. So things to think about when you're looking at cost of goods, because on a Schedule K, it merely will just say cost of goods. And one of the questions then that you need to kind of ask your client is, in addition to just the actual, whatever the inventory may be, if that's the case, or whatever the cost was for their materials, do they have any storage costs in order for them to store whatever the product is, especially if they do a lot of things out of their home? If they have labor costs that are not specifically outlined on the Schedule K, although they should be, or if they are paying into any type of pension or annuity plans for their employees, all of those things you need to kind of look at too, because it could all on the Schedule K be lumped into cost of goods, but you're going to need to be able to explain what all of those things are as well. So it's good just to ask the clients the questions about what is your accountant including in the cost of goods. In addition to the cost of goods, the expenses that are also not added back in as income are any capital expenses for the business. So if there are any specific startup costs that are related to the business, or if there are any assets, if it's an excavating company and you had to buy a new backhoe or you had to buy any type of equipment, then those are actual business assets that would not be included back in as income. Now, On the flip side, if you're using the backhoe for personal use, then you may have some portion that has to be included back in. But hopefully the cases are not quite that complicated. Other items that could be included back in also, like I already stated, are the use of the home. Use of a car is very important because a lot of people automatically assume all of the expenses related to a car need to be included back in as personal expenses. Not necessarily so. On the tax return, it'll specifically break down mileage for personal use and mileage for business use. So you'll be able to actually say, if I have $15,000 in expenses for the car, 8,000 miles was related to the personal use, and then you'll be able to calculate actually what needs to be added back in for the personal use. In addition, employee pay, things like that, we've already talked about. If there's any rent, taxes that are being paid, insurance, those are all valid expenses that are not added back in, as long as you're not paying your personal tax return or you're not paying for any personal insurance out of it, but medical insurance, things like that would be included. Rents and royalties is actually one of the items that is very similar to dealing with an S corporation. It's handled exactly the same way. So if you have rental or if your client has rental properties, then you're looking at the similar situation with the expenses. Are the expenses all related to that rental property? Are there travel expenses that are related to that rental property? Or is this all personal stuff that we're trying to just use for the rental property? So just questions to ask your clients so that you have some idea of what's really going on with the income that they are receiving. Other items that may be included but not necessarily are always included. If there's any type of overtime compensation, bonuses that people might receive, maybe they're working a second job, and we're going to go into these all in a little bit more detail. But if they've received any type of prizes at their work, if they've received any type of awards that have some type of a monetary benefit, that's something that they get every year or that you can prove that they're going to be getting again. And if there's any type of significant employment-related benefit. So what would that be? Would they have a car? If they're not paying for any personal mileage on a vehicle or anything like that because the gas is included, the car is something that they get, then that could be something that we would add back in because they don't have that expense now.
Expenses that are reimbursed to a payor or payee employee for business. But what you're looking for are those expenses personal or are they related to the business or employment? For example, an individual who might have an assignment abroad and their employer is paying for their living expenses while abroad on this assignment. Arguably, those really aren't personal expenses because the person on assignment, which is my example would be a temporary assignment, whether it's 6 months, 8 months, whatever the case may be, is incurring the expense because of the employment. They're not incurring the expense for personal benefit. So that reimbursement for housing, for utilities, those types of expenses won't necessarily be dumped into the gross income portion of the Form 14 child support charge. However, if you are with an employer who reimburses you for an expense, a personal type of expense that's not related to the employment itself, it is essentially a perk or a fringe benefit, that would be added back into the gross income column of the Form 14.
Anytime you're talking about any of the items that we just discussed that could be included in gross income, the most important thing to consider when you're determining whether or not to add, for example, overtime or bonuses back in is how much control does the employee have over the overtime or over the bonuses, etc. What is the likelihood that they will continue to receive the overtime and or the bonuses? And the biggest thing that I think a lot of us overlook because we just say, well, for the last 6 months the person's been getting this overtime. Well, was it mandatory or was it something that was voluntary? And how does it affect the parenting time with the children? Because when, if they're working overtime to fund the case, or if they're working a second job to fund the case, is that something that's going to continue? And if it does continue, how does that affect their time with the kids? I think that's probably the most overlooked point that most of us kind of look at because we're all kind of focusing on, well, they've got this income from a second job. Yes, but if they're going to be able to spend any time with their kids, they're not going to be able to be working 17, 18 hours a day. So that has to kind of come into play now. So just kind of think about that in the back of your mind when you're kind of going over whether to add any of these things in. Generally, if you're adding in any type of overtime, bonuses, anything like that, capital gains, the court will look at a 3-year average, just like they do with W-2s or any type of other income on tax returns, etc. So that kind of will give you a gauge. You know, if they've only received a bonus one time and it doesn't look like it's going to happen again, do you really want to include it in? If it's going to really put that person at a disadvantage to continue to be able to pay.
And the capital gains is an interesting topic because the question becomes whether or not that individual who has assets or stocks has actually realized the gain by way of liquidating the interest or the earned interest on the account. The law is pretty clear that if you are a payor or a payee and you have a stock account and you have earnings on that stock account but you have not realized the gain or you have not sold the stock to realize the profit, that really is not income to that party. The court's looking more to whether or not that's been liquidated, if it does appear on the income tax return, as being more directive of whether that should be included in gross income. And again, going back to what I stated earlier, it's not determinative. Again, the tax return itself is not determinative of what is gross income, but it's a strong piece of evidence that the court will rely on in coming to that conclusion.
And that's actually a really good point about the capital gains and whether or not it's been realized, because oftentimes what we all kind of do is say, well, we're looking at the statements from Fidelity and this person has $10,000 last year in dividends and they reinvested the dividends. Perfect example with Frank's point here is that they reinvested it. They did not realize the income from that. Yes, they probably had to claim some kind of a tax on their gain or loss throughout the year from what they actually received, but they didn't get the money. So it's important to realize, did they actually see the money, or was it just something that they have reinvested so that they could actually move forward, you know, with this investment and actually increase its value?
And it even gets a little more complex when you've got a stock account that may not pay dividends, but it's just increasing in value. Even in that circumstance, if you're not taking that increased value out, the courts are not considering that income.
Or shouldn't, anyway. Okay, retained earnings. Now what this has to do with, I'm sorry, yes?
What if you are contributing on regular to college savings on
529Cs. Are you asking if that would be considered income? No. The question was, if you are regularly investing money into a 529C for your children, then would that be considered as either parent's income, or would you get any type of credit? The answer to that is no, but it would come into play when you're talking about college, because obviously then you're going to want to try to figure out, if you're adding a college provision that the parents have to pay, how do you use this fund first? And what is it used for, how is it used, etc. Now, if you're getting creative in a settlement and it's something, let me preface this by saying the courts cannot give you a credit for putting money into a college fund. But if you're getting creative with a settlement, then you could work that out by going off the chart yourself, or by, you know, having in some way fixing the child support amount. So if the parent was going to put the money directly into that account as opposed to paying the other parent or something like that. But it's not something that the courts can actually do. They'll just take it into consideration when they're talking about the college provision.
Yeah, they're probably looking at it similarly to a 401k or retirement plan. So they're looking at the bottom, or the initial gross income number before there are those distributions to a retirement plan or a college savings plan. So.
And the other thing to remember also about the 529Cs, or actually if you have any custodial accounts that are specifically the children's accounts, but the parents are the custodians, the courts will not divide those, but they are under an obligation to actually order one of the parents to be the custodian. So because what the law states right now is that those accounts belong to the kids, but under the Uniform Minors Act, I can't remember the exact name of it, I'm sorry, but anyway, they have to have a custodian. So until they turn 18, somebody will be appointed as a custodian for those accounts. Okay? Any other questions before we move on? Okay, so retained earnings. Now this kind of goes back a little bit to somebody who has their own business. If you know, for example, you have an S corp and you have maybe a money market account that has $10,000 in it that you use basically as kind of your slush fund in case you run on hard times or whatever. You can make payroll, or you can pay for your everyday expenses for your business. Then one of the big things that the courts are looking at on this is, one, whether or not it's something that they can include in the gross income. And then how does that kind of come into play if you don't always have that particular amount in there, or if you do have to use it because you fall on hard times. So the big thing to remember is how much control does this person have over it? If you have a corporation and you have to go to a board of directors to dip into any of that money, or you're not responsible for distributing the money to yourself, then that's a little bit different than an S Corp. But when you have an S Corp and you're solely in charge, you have the ability to say, I'm going to give myself this $10,000. In that case, the court is more likely to say, we're going to include that in your income, even though it's the business account maybe, because you have sole control over how it's distributed. Okay, so something to consider if you're looking at that type of thing. As far as the employment-related benefits to consider and what can actually be included, this is what I was talking about again back with W-2, where we're talking about what's on line 12. If you have any type of non-taxable income or big employment benefits that can be included back in, here are some examples. If you have a flex plan account, if you know, like a HSA or anything like that, that offsets the cost of your health insurance, that can be included back in. And if you are contributing, or the employer is contributing to the 401k or a pension plan, that can be included back in, but only if the employee is the person who's in control of putting that money in. So for example, if it's an S Corp, and I have a 401k plan for my business, and I'm the one putting all the money into it, then that could be, those contributions to that plan could then be included back into my income. But if I am in a part of a corporation and the employer has some type of a match, then that's not something that would be included back in, because I, as the employee, don't have any control over how the employer puts the money into my account, okay? And now we are going to go into a little bit about what is not included in gross income, because sometimes there is some confusion with whether or not we can include some of these items in there.
And these are directly from the comments to the Form 14 Child Support Chart, Rule 8801. Specifically, TANF for temporary assistance for needy families payments, Medicaid payments, supplemental security income, and Social Security disability benefits, as well as food stamps. These are benefits that are not calculated into the gross income when using the Form 14 chart.
I did.
Great. Also, general assistance benefits, other public assistance benefits having eligibility based on income, and child support received for children that are not the subject of the proceeding is not considered income to either parent, whether they're the payor or payee. Another consideration is that people ask whether a new spouse's income can be considered in calculating child support, whether you're the payor or the payee. The simple answer is no. It doesn't get added back into, or it does not get added to the gross income of either the payor or the payee. However, it is relevant, and the relevancy comes into play in determining how much income the payor or payee has to contribute to the support of the child based on the contributions made by the new spouse to the expenses of that spouse. So if I'm the payor and I've remarried and I have a child support obligation, my new spouse's income is relevant to determine how much money I have to spend on my child, because I'm not paying that $1,100 mortgage by myself. I have an employed new spouse who's also contributing to that expense, which makes more of my income available to pay for the needs of the child. Now, when would this become relevant? Typically, it becomes relevant in circumstances when you're finding or making an argument that the Form 14 Child Support Chart, which is the presumptive way to calculate child support, is inappropriate and unjust. That argument then comes into play where you have perhaps an employee making $70,000 a year, the new spouse makes $300,000 a year, and then by tracing the expenses and income of both parties, you find that the payor spouse is actually not paying anything toward his own personal expenses, and you might even find he's been saving it. So would it make sense to follow the Form 14 chart in that circumstance, or should it be an off-chart case where it's unjust or inappropriate? So that's more of a gray area in the sense of what's the right answer, how should the consideration be presented to the court to make the successful argument that it's an off-chart case. And the key is a more in-depth analysis as to the availability funds of that particular parent.
But the important thing too is it's never included as part of that parent's gross income. It's only the income of both parents, not both parents and their new spouses or significant others, etc. Ma'am, you had a question?
Yes, so there's a husband who had children with a spouse who died, and then he gets remarried and has
so, I'm sorry, did everybody hear the question? Okay, the husband's wife dies and they have children. He's now receiving Social Security benefits for from his deceased wife for his children. He remarries, has another child. How do those Social Security benefits come into play with his income? It doesn't, because it doesn't have anything to do with the child involved in the case. And the benefits that are being received are not from either of the now parties in the case, him or his new wife. So that money solely goes to his kids. That's what they receive until they turn 18. Did you have a follow-up?
That can't be included or should not be included by the judge then in regard to making it a new report?
No.
It's not.
No, it should never be included.
Yes.
Would that person still be entitled to credit for it?
Okay, I'll get to the sword and shield. I'll talk about that right now. This is a new portion of the comments to the Form 14 that just came out recently, that if you are the person who is filing for child support, so mom files, and she's got 2 other kids, does she get credit then for those 2 kids on the Form 14? No, because she's the person who brought the action. So in the situation where this lady was just talking about, where dad has 2 kids, let's say mom files, they have 1 child together, and dad is now filed some kind of counter or whatever, but he's not the first person who filed. He gets credit for his prior 2 kids, but if she had any prior kids, she doesn't get credit for it because she's the one who brought the case. The rationale behind that is that you don't get to benefit from either pre-born or after-born children if you are the one requesting the change. On the flip side, if you're representing dad or mom in a modification, whoever brings the modification, even if it's 10 years down the road and they each have however many kids, the only person who gets to claim those afterborn children on the chart so that they get credit for that is the person who did not bring the modification. So whoever's bringing the initial action, it's just important to know who that is, because they do not get the credit if they're the person who brought the action. If it's a paternity action for the first time, it's the same as if it's a dissolution. Whoever brings the action does not get the credit. So if dad brings the action and he has 4 or 5 children, he does not get credit for those 4 or 5 children. He only gets credit for the children that are involved in this case. But mom would if she had other children as well. Is that clear for everybody? I'm still getting, you look a little confused.
Mom brought the story back. She had 1 job. She went out for it, but broke it out. Okay. So she cannot get credit for the 1 job.
That is correct. Yeah, whoever initiates the action does not get credit. That is correct. So if she had children prior, she does not get credit. She does not get to use that child to either increase or decrease her income, which it would be decreasing in this case.
So she would not get credit for 1 child in her care, and then that child support she continues.
The child support that she receives for the other child is different, because that would be lines 2B and 2C on the chart. She would not get credit for the child because that actually reduces her income, but she would have to claim whatever child support she's receiving for the other child on the chart. So it's very confusing as far as that goes, because she has to claim the child support, but she can't use the child in order to make him pay, dad now pay more money because she's got this other child. Yes?
I just wanted to clarify, so on so you're saying if mom has a prior child, if mom brings an additional divorce against new dad, a second kid, then she cannot be a prior born child.
Yes, and the reason for that is because when you claim the prior born child and you're initiating the case, then her income reduces. So that increases dad's percentage of the gross income. So the way that the new court cases came out, it doesn't allow you to have that protection where you're using all these prior children. Now, if for whatever reason down the road, dad in this case comes back on a modification and he's the one initiating the modification, then you can take into consideration if she's had any kids from divorce until now, but the first child's always out, always. Yes, ma'am. Interesting case. The question was, how are they handling babies that are born during the pendency of your case that do not belong to the dad? Obviously, it would be mom having the baby. Well, I guess not always. The courts do not let you have credit for that baby either. So if mom has a kid and they already got 2 children, she also does not benefit from now having a 3rd baby. So, nope. It's only based on the case that they have on file. So if they have 2 kids together and she gets pregnant and has another baby during the case, she does not get credit for that 3rd baby. And they would go the same for dad, obviously, too. Okay? Any other questions on sword and shield? Yes, ma'am.
With regard to, you said that mom doesn't claim that she's received, but she still has to list what she received in support.
She has to list what she receives as support and cannot claim that child. That's absolutely correct, yes. It increases her income, actually, because she has to actually claim the child support she's receiving as income. So let's say she's imputed anyway at $1,300 a month, and she's getting $205. Her income now goes up to $1,505. And then, so that reduces dad's percentage in this particular case. But she cannot get the credit when you claim the pre or after born children is based on your income. So $1,300, I don't know what it is, let's just say it's like $500. She can't get that reduction in her income, but she still has to claim it as income, whatever she's receiving for that other child.
So he gets to increase her income, even though it's not complete, because she has a child.
Yes. That is true. Go ahead. Well, what they're trying to, she asked, what is this supposed to deter, this new sword and shield law? What are they really trying to do? What they're trying to do is prevent people who have, a bunch of children. Now you're basically punishing the child in this case. Is essentially how the courts have kind of explained it. Because why should the child support in this case be reduced or increased because you have all of these other children that are unrelated to this case? So if mom already has 4 cases where she's getting child support, she can't now try to make this guy pay more. And I'm just saying her or him, I'm not really differentiating. But if she gets to claim all these kids, his support obligation goes way up because now her income is reduced by who knows how much. So the whole role is this particular dad is only dealing with his children and not being responsible for the lack of income she has for all of the other children as well. Anybody else? I do not know what case that it is actually because we didn't really include this because I knew it was going to be this whole huge discussion. But I will send that. If you guys want to come up and see me after, and if you have cards or you just want to write down your email addresses, I'll send everybody out the case law. But it also, the comments to the Form 14 that came out at the beginning of 2012, and also the changes to Rule 8801, have this whole sword and shield provision in there as well. And we included the comments, the new comments, on your jump drive as well. We just didn't put them in the packet. Okay, we'll move on from this, but I will be happy to talk to you guys outside, after this is over, if anybody else has any more looming questions about the sword and shield.
Okay, let's move on to expenses. This is section 6 of the Form 14 child support chart. There are certain expenses that can be added to the chart, and they're broken down, and we have some examples here as far as the child's health insurance costs, uninsured medical costs, other extraordinary costs, and the like. So I think let's move on to the daycare costs, and let's talk about that first. Daycare costs, there is the Form 14 child support chart allows for the inclusion of the daycare expense. It accounts for the tax credit in the chart itself. So the bottom line number that's included in the Form 14 child support chart is the net number after the tax benefit. And then that number is then what is considered in the division of that expense. Now, daycare expense, typically, although there is a provision for it in the Form 14 child support chart, we try to have that excluded or calculated outside of the chart, which really benefits not just the payor, but also the payee as well. For from the perspective of this is typically not a long-term expense through the minority of the child. It will terminate long before child support obligation will terminate. So it's always better to try and deal with that outside the charge from the payor's perspective. From the payee's perspective, it's also good in case there are changes in that expense up, if there increase. That increase would not be accounted for if it were calculated into the chart, but if it were calculated and by way of having a provision in your divorce decree or parenting plan requiring a sharing of the responsibility of that expense, that would account for the fluctuations in the expense, whether it's up or down. So one thing to keep in mind with the daycare, if you have a payee parent, that is the custodial parent, who incurs a work-related daycare expense, but the income they earn from their employment is less than the work-related daycare expense, neither figure can be included into the child support chart. Okay, so and which also goes for the proposition that you can't have a daycare expense without employment income from the party incurring the work-related daycare expense. Also, if we go on to the next one, the child's health insurance costs. That's the next line on the chart on the expense portion of the Form 14 child support chart. What that allows for is the inclusion of the out-of-pocket expense for the parent incurring health insurance coverage for the child. Now, if that parent has remarried and the new spouse is actually covering the insurance costs for that child, case law states that that premium payment may still be added to the child support chart if it's the new spouse of the payor or the new spouse of the payee. So the payor or payee themselves don't have to actually pay the premium if their new spouse is paying it for the benefit of the child, and it can be included into the chart.
Just one, did somebody say they have a question? Yeah. Okay, go ahead. Good question. The question was if the premium amount doesn't change no matter how many children you add to the plan, or if you have like a family plan, the premium's always going to be the same. How do you calculate what the amount is that goes on the Form 14? If it's one flat amount for the entire family, you take the flat amount, you divide it by the number of family members, and then you multiply it by the number of children that are to be covered, and then that's the amount that goes onto the chart. So, for example, if it's $500 a month for the entire family of 5, you have 3 kids, $300 a month would go onto the chart.
And I've seen it the other way too, quite frankly. I've seen it where the courts have said, this is not an additional expense to you, therefore it shouldn't be included. You're going to find that a lot of in treating some of these, or many of these expenses, there's a lot of discretionary authority with the court, and I'm sure you probably run into the circumstance where the judge is unwilling to add in anything because they see the before and after expenses being the same. Shouldn't stop you from making the argument, though, because there are judges who do allow for that division of that responsibility, taking the position that that would be the more equitable way of treating the insurance premium, but it's going to be knowing your judge and making the right argument.
He doesn't have to, but there's case law going both ways. So there's case law that says that it's been upheld by putting the entire amount, by putting nothing because there was no increase, and then by dividing it by child. So you could find the case law out there for any of those things. And one last thing too to kind of consider when you're talking about healthcare costs is if you have a PDL or a temporary award for someone to pay child support that includes a cost for health insurance, then when you get the final award, you cannot double dip, is what the court is basically saying. So the award for health insurance has to be prospective, not retroactive. So if the kids are covered by Medicaid, or if mom's covering them and it's actually in the Form 14 that's part of the PDL, and you're representing dad who's been paying and now he's being ordered to pay or whatever, make sure that there's a retro award. It does not also include what the cost would be all the way back to how far the retro goes for the health insurance, because then he would basically be paying the same expense twice.
And actually, the case that's cited in here, it's important, if the court's following the Form 14 and the health insurance premium is included in the Form 14, and there's a retroactive award of child support, certainly the court could order a retroactive order of child support, but what the case is saying is that if there was already coverage, and the payor is essentially double paying, that a retroactive order should not include the health insurance component of the new Form 14, because that's double dipping. No, it only goes to the bottom line.
Let me repeat the question, I'm sorry.
Oh, sorry, go ahead.
Let me repeat the question, because I know a lot of you probably didn't hear. If the parent is remarried and the new spouse is paying for coverage for the entire family, including the child, the question was, how does that affect the paying parent's income? It doesn't, but it does get included on the chart. However you calculate the health insurance cost, that would still be able to be included.
But in a backdoor way, it is relevant, because we're going back to how much of new spouse's income is making payor spouse's income available to pay for more expenses for the child. So it's still relevant.
Right.
But the strict answer to the question is no, it doesn't get added as gross income to payor.
Any other questions on that? Yes, ma'am. It should. The question was, if you have a child support enforcement case, does this case law, I'm sorry, I'll go back. Does this case law affect what child support can do as well? It should, but as we all know, dealing with child support, they kind of do their own thing. But if they do order retro, and we know they do this often, and it doesn't, there was already an order in place, so they'll do medical orders frequently for health insurance, then that's a very good consideration for if you're doing a petition for judicial review or you ask for a hearing based on whatever their recommendation is. And they should follow the law, because the law trumps the agency, but that's a whole nother ballgame.
So then the next line in section 6 deals with what are called uninsured medical expenses that are agreed upon or court ordered. And these are really expenses that exceed the $250 amount each year. This is directly from the comments to Form 14. What we're talking about here, though, in establishing or identifying these medical expenses is we're looking for medical expenses that are predictable, that are recurring, and that are quantifiable. So it's those three components that really need to be examined to determine whether that's an appropriate expense that gets funneled into the Form 14 child support chart, line 6D, I think, yes. So, we may have a situation where a child may be getting their tonsils out. This is not a recurring expense. It's not appropriately added to the Form 14 child support chart. However, a child who's on ADD medication, that in all likelihood is a recurring, predictable expense that's quantifiable that can be added to the chart on line D. So that's what the court's looking to assess whether that's an appropriate expense to be included in the Form 14 child support chart. Now, you may have those other uninsured expenses, like my tonsillectomy example, or where it's a one-time expense. Who's going to cover that expense? You can add a separate provision to the parenting plan or ultimately the divorce decree that assigns out responsibility for proportional or some percentage share for each parent to pay for whatever uninsured medical expenses are incurred after the entry of the judgment. And you don't, or the court doesn't have to find the Form 14 child support chart to be unjust and inappropriate to have that provision outside of the Form 14 chart. But that can be dealt with that provision that's separate from the Form 14 chart.
The other thing that's really important with whether you're dealing with uninsured medical or extraordinary expenses, et cetera, on whether to put it on the chart or off the chart, is that you have to have something that's ascertainable. So, for example, if you know you have therapy for a child that is going to be in therapy for a very extended period of time, and you know that the cost is going to be $150 per month, that's something that you could include on the chart. if anything is off the chart, you just have to be careful that you're not putting them in both places, because there have been many cases where the cases have been reversed and remanded because they put it on the chart and then they also expect the parent in a separate order. They'll say you have to pay 50% of any uncovered, medical, whatever. So just be careful if you're putting it on the chart that it's not something that's included in a separate order as well that they have to pay.
Then line 6E, which is the last line in section 6 regarding expenses that can be added to the Form 14 child support chart, address extraordinary expenses. It's a very general statement. Unfortunately, practitioners tend to be very broad in their interpretation of expenses that can be dumped into that chart. Certainly the expense has to be quantifiable and to some extent predictable and recurring. But also that expense that it has to be shown to benefit or enhance the athletic or social or cultural development of the child. So an example, we'll see here on the screen.
Oops, one more, sorry.
Whereas the Pickering case talks about a cell phone or a car insurance. These are not expenses that were intended to be included in the Form 14 child support chart on line 6E. Yes, they're recurring, yes, they're predictable, yes, they're quantifiable, but they don't enhance, or the court has concluded, they don't enhance the athletic, social, or cultural development of that child. So these are not expenses that get added in. We're talking more specifically, music lessons, travel, certain travel, actually travel associated with camps or lessons, because again, you still have to have that recurring, predictable component to be added. But absent that evidence, it's not something that should be included in the chart. Like uninsured medical expenses, although it may not meet the components or the criteria of being an expense that would be included in the chart, you can have a separate provision in your parenting plan that divides up that obligation. Again, the trial court is not required to find the Form 14 child support chart unjust or inappropriate to have that provision. And you could also conceivably have numbers or have an amount on line 6E for certain expenses, and then have another provision that covers expenses that are not specifically in the chart. It doesn't happen very often. It creates a lot of confusion. You really have to, in a case like that, specifically identify what the 6E expenses are, so there isn't overlapping in that obligation. All right, private school tuition. This is an expense that could be added in line 6E, but it's a different type of expense from our experience, those of us who practice in family law. It's not something that's an obligation that's easily undertaken to require a payor or payee spouse to be responsible for. What the courts are looking for in case law is laid out the burden of proof, is that obligating a parent to pay for private school tuition, I'm talking about elementary and high school, I'm not talking beyond high school. The obligation or the burden of proof is that you have to show that that private school education provides something that the public school alternative does not. And religious instruction is not one of those, it's not an exception or not a condition that allows for that. It has to be something more than that or something different than that in order to obligate a parent to pay for private school tuition. So it's the other consideration, of course, is obviously, we see it as obvious, but not all the courts do, is the feasibility of obligating a parent to pay for that private school tuition and whether they are in a financial circumstance to be obligated to pay or contribute to that expense. So it's essentially a two-part analysis of whether or not the private school tuition should be an expense a parent's obligated to pay for.
And just a couple of things touching on that. I know many of you have probably been in front of Judge Crawley, and if you're in the city, he thinks that being in the city is an educational need. The appellate court has not upheld that. So that's one thing to kind of take into consideration, is the location of where you are. There are some cases out there also that state that if the kids have been in private school, like let's say they're in junior high, so they've been in private school for at least 8 years, maybe 9 years, and we're talking about whether or not to deal with a high school provision that they need to go to private school. There are actually several cases out there that state that the court can take the emotional well-being of the child to move to another school based on the trauma of the divorce and all that stuff as an educational need. And they actually have reversed a couple of cases where the judge said, no, I don't think that there's an educational need based solely on that fact that there was all this trauma to the kids to have to change schools. But all of the cases, even if they say, okay, that's an educational need, they all come back to can the parent afford it? And there are many, many cases out there where they have overturned a award of the private school if there's a parent who's unemployed, underemployed, simply can't afford it. And here's the other thing to consider too. Most of the judges will not give you a credit on child support if there is an order for private school. So in most instances where private school is being awarded, you're paying a child support obligation, plus you're paying some type of a private school. So, these are the kind of things to consider, and definitely have, know the judge that you're in front of and what their opinions are on private school if this is even an issue that is possibly coming up in your cases. Yes, ma'am. Good question. The question was if private school is ordered and the child gets some type of scholarship, is that included? No, and this is why, because when you're doing the Form 14, you have the number at that moment of what the tuition is, so you don't really have any way of knowing what the scholarship is. So this would be an example of something that you might want to go off the chart, so that you say that the parents pay, similar to the college provision, they pay absent or after there's any scholarships or financial aid that's applied. Because in most cases now there will be financial aid if they're going to be going to private school after a divorce.
And clearly if the scholarship was known at the time of calculating the support, it
Right.
could be balanced against that. So it would be the actual cost.
It would just be really hard at that point to know next year, are they going to get the same, or is the cost going to increase, and are we just going to be back because somebody's not paying something they should? Yes, ma'am?
In the case of modification, if a child has been going to private school and has like 2 more years, say to 8th grade before they end up in high school, and the parent decides to put the child in a public school, is that tuition that the parent is paying, would that then become child support, or is that just no longer necessary?
The question was if a parent is paying, correct me if I'm wrong on this, if a parent is paying for private school and then the other parent puts the child in public school, what happens with the money that parent was paying? It would have to be some type of modification. Because if they have volunteered to pay for the school, either it needs to be written in there that if they go to public schools then that payment ceases, but it would be separate from child support because there's probably going to be a separate order that says they have to pay a certain amount of support as well.
Now, that's the same problem you run into in daycare. When you have daycare, the child ages out of daycare, if it's in the chart, you're still paying the daycare expense unless you're going back and modifying the chart, which is why it's best to deal with that type of an expense outside of the chart.
Any other questions on that? Okay.
College costs. College costs are not costs that are dealt with in the Form 14 support chart. Actually, it's a separate provision, and it's the case law. It goes back to the Eckley case or the Eshel case, it goes both ways, which outlines what would college costs consist of: tuition, room, board, books, fees, and other reasonable and necessary expenses. It has that catch-all. The question is then, what is reasonable and necessary? And I know what often comes up is like sorority dues and such.
Yeah, well, here's the case law out there. I just recently had this on one of my cases, was sorority or fraternity fees, are they included in the cost? Well, not according to the case law, because that's the definition from the case law. So if it's an agreement that's going to be something that's included, here's where you run into a problem and where the case law is not very clear. If they live in the dorm for the first year and then they join a sorority or fraternity and now they're living in the sorority or fraternity house, so that's where their room and board and their food and all that stuff is being handled, then it's considered part of the college cost. So in drafting your agreements or in presenting your proposed judgments to the court, it's just important to differentiate what you want included as a cost and how you want to handle those types of things that come up, because you definitely would have to then pay for the sorority fees if it does include room and board and food.
Now, as far as the tax dependency exemptions, the Form 14 child support chart presumes that the custodial parent or the payee receives that benefit. It's structured into the actual calculation, so when a court or when individuals try and settle a case where they're transferring that exemption to the payor spouse, that is a deviation from Form 14. If you're trying a case and the court awards that tax exemption to the payor spouse, the court must find that the chart, or the Form 14 child support chart, is unjust and inappropriate in order to make that award, because it is not, it is presumptively the property of, or I shouldn't say property, it's presumptively the benefit of the payee custodial parent. So any transfer of that obligation requires that finding of unjust or inappropriate at the chart amount.
And I think that we all have had this conversation with many of our opposing counsels. It does follow the Form 14. If mom's getting support, then she gets the tax exemptions. But the school of thought on this has really changed over probably the last 2 years. And just before Frank goes into what the changes are, the increase is $100 per child. It's now $3,900 beginning in 2013. So if you're talking about 2 or 3 children, then you're looking at a significant amount of money somebody could be getting from their taxes.
And I'm going to skip just ahead real quick, just to the most recent 2013 case that we were talking about. The Thorpe case. This is a case that where the trial court calculated a Form 14 child support amount and decided to award to the payor parent the tax exemption. But in exchange for that, the trial court increased the amount of support paid by the payor to the payee to compensate in part the payee for the transfer of the exemption. It wasn't a dollar for dollar compensation. It was probably 1 to 2 or 50% payment for that exemption. And what there was a challenge on that on appeal, and the Court of Appeals upheld that, saying that this is, of course, not following the Form 14, so it's found to be unjust or inappropriate, but the trial court had the latitude to treat the transfer of the exemption that way by also increasing the support amount to compensate the payee somewhat for the transfer of that exemption.
And this actually, for those of you who don't know, this was a Judge Essner case that went up. And the Court of Appeals actually stated that even though he wasn't taking the full amount that the father would have been receiving on the tax exemption, so he wasn't making him pay $3,900 divided by 12 and adding that into the chart, because they were compensating mom in some way, that was appropriate. So there's not really a formula, but as long as you know that that's an option. And there's also another case out there, which is the Cole case, and I can provide you with the citation for that, 397 Southwest 3rd, 510. It's a 2013 case.